Good morning, everyone. I'm Mina Sirkin. I'm an elder law attorney here in Los Angeles County. And today I have here with me Christine Brown, an elder law attorney in Torrance, California. And she is going to be talking with me about what happens in a person's life when they are no longer competent. So we previously had a segment on a different video where we talked about what happens if you need to get a family member to help you and you're still competent. So today I have some questions for Christine. And Christine, can you tell me first a little bit about your practice?
Sure. So nice to see you, Mina. Like Mina mentioned, I am an estate planning and elder law attorney in Torrance, California, and my practice is limited to conservatorships, guardianships, estate planning, probate, trust administration, as well as special needs planning.
Perfect. Christine, can you tell us a little bit about what happens when a person's no longer competent, and are there ways that family members can help make decisions for him or her?
Sure. Like you mentioned in our last video, when somebody is competent, they can execute a power of attorney for finances or an advanced healthcare directive to have someone help them out with their medical and financial decisions. If they don't have the mental capacity to understand those documents, then they can't execute them. So in order for someone to help you out with your personal and financial decisions, your family members may have to go to court, usually the local superior court in your county, and establish a conservatorship of the person or a conservatorship of the estate. A conservatorship of the person will allow your conservator to make decisions about your medical treatments, procedures, medications. They will also be able to determine where you live, be it in your own home or an assisted living facility or even skilled nursing if that's something that you require. They basically will end up making all of your medical and personal decisions that you were previously making for yourself. There's also a conservatorship of the estate that allows the conservator to manage your real property, your bank accounts, your stock brokerage accounts, mutual funds, life insurance policies, retirement plans. Again, using those assets for your benefit to make sure that they are maintained and only used for your care and your needs.
So if, for example, if somebody has a family member who is in the hospital and the hospital wants to release them, is there something that a relative or family member can do to take over that process fast?
Yes, there is such a thing as an ex parte or emergency temporary conservatorship. Here in California, in order to file for an emergency temporary conservatorship, you also have to file for a permanent conservatorship. The way it works is you file your petition for conservatorship. Your hearing is about 4 to 6 weeks out into the future. If something arises where you need to be the conservator before your hearing, you have to petition the court with an ex parte petition, in which you have to describe what the urgency is. It can't merely be because you don't want to wait 4 weeks for your hearing, but it has to be an emergency situation that will affect the conservatee. So for example, one of the examples that Mina and I see probably all the time is you have a loved one who is no longer mentally competent. They're being discharged from the hospital and the discharge planner is sending them home. Well, the family knows that they can't make decisions about living at home. They can't hire a caregiver. They may not even be able to appreciate the dangerous situation that they're going to be in. So you may want to do a conservatorship, a temporary conservatorship of the person at that point. Or maybe another situation that we unfortunately also see is somebody is taking financial advantage of the older adult. So let's say a family member or a stranger is in the process of getting the older adult to refinance the house to pull out hundreds of thousands of dollars of equity, which we know that stranger will run off with the money and the older adult won't have it. Or maybe somebody is writing unauthorized checks on the older person's bank account. So you need to stop that immediately. You cannot wait 4 to 6 weeks for your hearing. So under those circumstances, you would probably be granted a temporary conservatorship.
And are there documents that people should gather before they come and see you about a conservatorship?
Yes, definitely. We understand and appreciate that sometimes you don't have all of the facts, but we really stress that you bring a medical capacity declaration form to the first meeting. This is a form that we give you. It's ultimately filed with the court, but it gives us a good idea of the incapacity of the person. I know early on in my career, I was burnt once or twice when family members or well-intentioned friends say, oh, so-and-so's incapacitated, and they get the medical capacity declaration form, and there are little, if any, deficits that the older adult is suffering from. And as Mina knows, if you don't have medical support for a conservatorship, you will probably not get a conservatorship established for your loved one. The second documents that we ask for are a list of assets as complete as possible so that we know exactly what assets we're dealing with and the value of those, all of which is needed for the petition. And we also ask for a copy of your loved one's estate planning documents, because there have been many times where people come to us and say, oh, I need a conservatorship for my uncle. We look at the estate planning documents, we see that the uncle has a trust, he has an advanced healthcare directive, he has a durable power of attorney. So we've eliminated the need and the cost of a conservatorship, and we're still able to help the family with a trust administration and guiding or giving our client direction on how to work with an advanced healthcare directive and a power of attorney.
Great. Christine, can you tell us again how people can contact you to discuss conservatorships in Los Angeles and Orange County?
Sure. You can go to my website, which is www.southbayelderlaw.com. You can email me at Christine, which is Christine. I just have to spell it because there's so many different ways to spell Christine, at southbayelderlaw.com. Or you can call my office at 310-782-6322.
And I'm Mina Sirkin. You can contact me at 818-340-4479. You can also email me msirkin, that's M like Mary, SIRKIN, at sirkinlaw.com. And either myself or Christine will be able to help you establish conservatorships and handle your elder law matters in LA County and Orange County. Thank you for being with us.